Hi, everybody. Okay, so in this video, we're going to talk about the King of Courts bench rules and how the orders that Miss Aquila has written in the past and present are violating the King of Court bench rules. And this, again, speaks to the level of discrimination. Now, if the King of Courts bench rules apply to one party, they should apply to the other party as well. Um, this isn't the first time that my constitutional rights have been violated. Um, I'm sorry, I should have said that a little bit better. The trial was not the first time my constitutional rights were violated. Back at the beginning of this court case, when we went for the triage hearing, Douglas Mayer at the time was my lawyer through legal aid. A week before the triage hearing, he withdrew from being my lawyer, and he was allowed by Miss Master Goldenberg, who heard his motion and allowed it. Now, legal aid should have given me a different lawyer at this point in time, but being only a week before the triage, that didn't happen. So I went into the triage hearing, and um, I I cited the Constitution. I said, under 15.1 and 15.2 of the Canadian Constitution, I'm requesting an adjournment. Justice Peterson told me that the Canadian Constitution does not apply in this matter. Um, it doesn't apply to triage hearings. Now, to me, that seemed really odd that Canadian law, federal law, didn't apply to a Canadian court. But I didn't really have any say in the matter. So, um, and Miss Aquila was citing some section of the King of Courts bench about a speedy court process. So, and I didn't know the King of Courts bench rules. I still don't really know the King of Courts bench rules that well, but I have briefly looked them over. A few things that I've noticed that she has broken, and keep in mind, like I said, if the King of Courts bench rules apply to one party, it should apply to both. And if both aren't following the King of Courts bench rules, neither party should be required to. Um, And then there's the other question: does the King Court's bench rules overrule the Canadian Constitution, which is federal law? You know, but we won't get into that part right now. I want to show you how the King of Court's bench rules have been continuously violated throughout this court case. So if you go down to Rule 16, which we're going to do, and you might need a magnifying glass for this. Again, I apologize. Um, If you go to uh, if you go to 16.14 B, it says any documents that it is not required to be served personally or by alternative to personal service may be served on a party acting in person or on a person who is not a party or on a party whose lawyer has ceased to practice with no notice of change of lawyer or um, of intention to act in person has been filed. So that would apply to me. Maybe mail by mailing a copy of the document to the last address for service provided by the party or persons. If no such address has been provided, to then the party's or person's last known address, or by personal service, or by alternative to personal service. So I didn't receive a mailed copy. Yes, she knew my address. I have lived at I've owned 46 Bramwell since 2018, so the duration of this entire court case. So um, for me to not get a mailed copy violates the King of Court bench rules. But for let's play devil's advocate for a minute and say, okay, um, she's doing the alternative to personal service, which should only be done if um, if she couldn't mail a copy from the way I read these rules. But let's say she did alternative service instead. So if you scroll down to um, alternative to personal service 16.31, so we're going to do that. So that's the bottom, it's at the bottom of the page there. I'll let you read that for a second. So what it says is, where service by an alternative to personal service is permitted, service shall be made in accordance with this rule. Acceptance of service by a lawyer, well, I don't have a lawyer, so that one wouldn't apply. Representation of authority, by accepting service, the lawyer shall be deemed to represent the court, that the lawyer has the authority of his or her client to accept service. That one doesn't apply. Service by mail to last known address. Service of document may be made by sending a copy of the document to the last known address of the person to be served. Well, she knows that my address is 46 Bramwell, and that did not happen. By registered mail or certified mail, in which case service by mail under the clause is effective on the date the document was delivered to the person to be served, as shown on the confirmation of delivery obtained by Canada Post Corporation, or by regular letter mail with acknowledgement of receipt enclosed with the document, in which case service by mail under the clause is effective. Only if the acknowledgement of receipt form bearing the signature that purports to be the signature of the person to be served is received by the sender. And two, on the due date on which the sender receives acknowledgement of receipt, signed, provided in subclause B1. So none of this happened. So the alternative to personal service never it is email. The only time email is acceptable from reading the Court of King's Bench rules is when um, service is happening between lawyers, from my understanding, and it defines that. So if you scroll down in the King of Courts Bench rules, it talks about email service. So email service requirements. First of all, if you look at the heading, it says service on lawyer of record. Well, I'm not a lawyer, so I shouldn't be emailed this. It should be going through the proper channels, as indicated in the King of Courts Bench rules. But I have been continuously emailed documents, and it has been allowed by the courts. So while one party is expected to follow the King of Courts Bench rules, the other party is allowed to continuously violate the King of Courts Bench rules. Where email service um, is permitted between lawyers and only between lawyers, from my understanding, it states that the email message to which the document served under Clause 1E is attached shall include the sender's name, address, telephone number, and email address, the date and time of transmission, and the name and telephone number to the person to contact in the event of transmission problems. I don't think C was followed on any of the emails, but I'm not 100% sure because, well, I just didn't really look that closely, to be honest, but I'm going to now. But regardless, um, the email the email service is not following King of Courts Bench rules. And I think I have effectively proved that the King of Courts bench rules are not being followed. I also want to speak to how it promotes harassment and discrimination because, well, the discrimination, like I said, if one party is expected to follow King of Courts bench rules, the other party should be expected to too. And if one party is not expected to, then the King of Courts bench rules essentially should be thrown out the window because you can't, it's discrimination to expect one party to follow one set of rules in, in a court case. And I'm saying that incorrectly. It's discrimination to expect one party to govern themselves in accordance with the King of Courts bench rules, while permitting the other party just to do whatever they want. Um, so there's that, and it also promotes harassment because regular mail takes a certain length of time. There is a reason that regular mail is nicknamed snail mail. With with Miss Aquila emailing me, that means that, well, a perfect example is what just happened. So she's creating an order without going through the due process of obtaining a disposition sheet and writing the order in accordance with what the disposition sheet says. And then she emails it to me, demands that I sign it within 7 days, which would not give me enough time to order the file from the basement of the court office where it is kept, apparently, and to arrange a time to go down there, photocopy it, look over the disposition sheet, look over the order in comparison, and write a response. Like that it takes more than 5 days. And so, and keep in mind, during that process, I'm going to have to take time off work to go down. Now, thank goodness Charlotte emailed me the disposition sheet. Just so everybody knows, I have requested numerous documents from the courts. I have never once been emailed them. That was an oddity. And thank you, Charlotte, for helping me with it. I really do appreciate it. Because, I mean, like, it creates a level of stress and harassment because now she's signed the order. She's demanding that I look it over and sign it within 7 days. Otherwise, she's going to send it to the judge. So the harassment comes when I'm not able to verify the order versus the disposition sheet because I don't have the disposition sheet. Now, thank goodness, like I said, the Court of Appeals, they sent me the disposition sheet, so I was able to look it over and respond. But had I not been able to, now I'm expected to sign an order that I cannot verify because Ms. Aquila has been able to utilize the email versus regular process. If she had utilized regular process, well, the process was taking place with the mail coming to me, her creating the order and it being delivered and all that stuff. I could have been at the courts ordering the disposition sheet, but that time frame, that period was never allowed to me. Anyways, so now I've got the disposition sheet. Now I've got the draft of the order, and in it, she's stating that she is not going to follow King of Courts bench rules. She's not going to follow the regular means of delivering the order. She's not even going to follow the alternative to service. She is going to do her own thing, and it is going to be allowed. And if I don't sign this order, now I only have a few days before she takes it to the judge and expects the judge to sign off on this. Which, well, if the judge signs off on it, she's just proven discrimination from more than one party. But I don't know. we'll see. We'll see how it goes, and I will update everything in the next little while with what happened with the order as I find out. Also, I will be uploading the email from Miss Aquila in respect to her threatening to get the judge to sign if I don't sign it.